Thank you for joining us on Bees on the Law, legal talk from the boss perspective. This podcast is for informational purposes only and is not intended to provide legal advice and is not meant to create an attorney-client relationship. Also remember, laws change and differ from state to state, so this is not a substitute for seeking legal advice in your jurisdiction on the current law applicable to you.
Hello, welcome back to 3 Bees on the Law. I am your Illinois, Wisconsin bee, Susan Dawson.
And I'm California bee. Sorry about that. I'm California bee, Camille Canale. Welcome.
Welcome. So we thought that we would take an interesting trip down workers' comp land for employers, but we wanted to do it with a different spin. We wanted to do it with talking to a plaintiff side counsel who can talk to us about some of those best practices and ways that employers can, if you can't completely eliminate workers' comp, which you can't, but you can at least make it a little bit less painful both for you and for the employee's experience. So I invited Jim Coogan to come in. He's a principal and trial lawyer at CooganGallager. He is a plaintiff side personal injury and workers' comp attorney. So he's the guy who represents that injured party. Welcome, Jim.
Hey, thank you so much for having me here, both of you. It's my pleasure.
Well, great. Well, let's just kick it off right from the get-go. So really, what are some of those biggest mistakes you see that employers make when an employee files a workers' comp case?
So I guess my principal thought here is think about it from the employee's standpoint. As the employer, you're probably frustrated. It's more paperwork. There's some issues you have to deal with, including the fact that the employee will be off of work for a while. So you have to deal with that. But on their side of things, they're injured. That's a problem. Transportation is probably an issue depending on what kind of injury it is. And in the immediate term, they're worried about getting paid. So in order to make the whole process less adversarial and probably leave less of a bad taste in everyone's mouth, documenting everything, putting the forms together, filing them, getting notice out to the claims people at your workers' compensation insurance company. I mean, if you don't have a lot of claims, you might not even remember who it is right away, but gather that information and start the process, because the quicker that starts, the quicker they are able to access the benefits that they have, which in basic, I think every state has the same general structure, which is they're going to get paid for the time that they're unable to work because of the medical condition. And they need the medical treatment, which is supposed to be paid for by workers' comp. So the faster that's all in place, the less you'll have a delay, a problem, which can then lead to motions being filed, which, on the employer's side, if that happens, you'll have more hassle to deal with as well. The claims people will be calling you, counsel might be appointed, and they're calling you, asking questions. They're interviewing more people at your company. If there's no hearing, then they don't have to do any of those things. And they still may have some basic investigation, but all of that should make everybody's life less stressful and probably make it less complicated when it's all wrapped up and done.
And I think sometimes people forget that these are humans. So if there's a delay on the employer side, the employee is going, what are they trying to do? Why are they trying not to pay me? Oh, if they're going to be trying not to pay me, then fine, then I'll, right? And so, there's a lot of employee personality, both sides going on there as well. I did want to say though, Camille, he said your favorite, he didn't say it, but he said it. Document. Camille's favorite. I'm going to get you a t-shirt one day, Camille. This is document. It's one of her favorite things to talk about.
Yeah. You don't, I'm sure the fact that you put everything down right away before things are forgotten, before you don't remember exactly where and when and who, that's going to lead to less problems too. But I don't want to interrupt any other document implications that you might have had. Sorry about that.
That's okay. I think too, and one of the things that you kind of did, you implied it, but didn't quite come out and say it, is communication with your employee is key so that they know that you're at least trying. So for example, if you're trying to get a hold of the adjuster because you need forms or whatever, just letting the employee know that you're following up and trying to do the right thing, because it's not happening instantaneously, it sounds like, is a huge component, especially if things aren't happening as quickly as the employee would like.
Well, and it's an unusual thing. It can be awkward because you feel as if suddenly I'm sure sometimes it even feels as if there's a lawsuit that's been filed, which it's really not. It's an administrative claim. That's how they handle them in Illinois, and essentially everywhere else. It's the same general process. And you don't have to be in a situation where never talk to the employee while this is, and it also doesn't work. There has to be lines of communication for when that person's getting their work status, and they may be on partial release to come back to work, or eventually on full release. If there's no line of communication, it just makes it more difficult for the employer to even have some idea of when they can expect that person to come back.
What other types of steps, even ahead of the claim being filed, can an employer take to minimize workers' comp liability? Because I think that's a big one, is avoiding the claim altogether sometimes.
Look, there are lots of rules. There's lots of guidance. There's lots of things out there that I know that this is why this show exists and why employers need good counsel, because there's so many things that you have to do these days if you're running a business. But it doesn't mean you can skip some of them or forget to do trainings, to have a system in place. If you have a physical, labor-heavy workforce, they're more likely to get hurt for a variety of reasons. But you can certainly minimize that by training your supervisors to look for possible problems, and then making sure the supervisors are training the employees. Lift with your knees. There should be, signs in different places. There should be different equipment that can help them avoid overstressing their back or overstressing their knees, if that's the sort of job there is. Just having systems in place in general where there's oversight is going to minimize the opportunity for injury in those physical jobs. Now, in the less physical labor jobs, food service, or even office work, there's not as many opportunities to get hurt in those places, but, make sure it's a clean work site. Have little things like, occasional working through a cleaning day once a quarter or something like that. Because people, when we get office injuries, it tends to be something where as simple as tripping over something. And then once in a while, it can lead to a fairly serious injury, which is unfortunate for everybody involved, because you don't think of sitting in a chair and going to the copy machine and going to the water cooler as a high risk proposition. So you want to minimize those risks, and all of those things will then acquit to your benefit, because your premiums will be lower, because the insurance company is going to think it's not a place where people get hurt.
What about stress claims in an office?
I was just going to say really quick before you say that, my business partner is going to love this podcast, because we have an annual cleaning day. And look at that. It's official. It's officially recommended.
It can't be good. It can't be a bad thing for any reason, right? You got a nice, fresh place, clean place to work. Your mind is fresh. You got a clean desk. Right. I think you asked about stress. At least in Illinois,
now I'm thinking about Clorox wipes, because that's my cleaning thing. So anyway, we digress. I'm sorry. Back to stress.
Right. Stress. So stress as a disability has been a big topic, something that goes on a lot. Something that Camilla and I have talked about in a number of podcasts. So that's why we were throwing out there, what about stress as a workers' comp claim?
Generally, it's not going to be recognized as a workers' comp claim. So you can have mental issues as the result of a physical thing, where someone maybe it is a retail or food service, and they were stuck up in a robbery or something like that, and there was a physical altercation that can lead to, like, even a PTSD claim could happen. I think you're talking about general workplace stress. For the most part, the law is not going to recognize stress, especially if it's the regular work stress that people go through, and it's not some objectively difficult, unusual thing that's unique to that person that they were put through. And there's claims that, at least Illinois has this phraseology that says a mental claim, like it's mental anguish or stress as the result of something that they were only experiencing psychologically, that there was no physical component to. They're very difficult claims to prove, and a lot of times we're scrutinizing them if somebody calls with that, and mostly counseling them that it's not a very strong case, unless something, there could be outliers. But no matter how stressful a workplace is, it could instead be something where they should be taking time off, or even a short-term disability claim if that employer has that kind of a program for their employees. Most of the time in the workers' comp law, even though it's evolved somewhat, is derivative of an industrial workforce. All these laws were written in the early 1900s, thinking about limbs being hacked off, or a serious knee injury, back injury, something that makes it so the person cannot work. that's not to say that this couldn't be evolving, because everything has over the last 20, 30 years, and especially in the last, even the short term, the last couple of years, we're looking at workplaces and stresses differently. But it would have to be amended. Somebody would have to pass a law to amend workers' comp acts in a state to specifically acknowledge that. It's not here in Illinois. It could be somewhere that I'm not aware of, but I also think it would probably require some very specific proof.
Yeah, I think in California we do see them from time to time, but I do think they're difficult to prove. And typically they come along with an employment claim, like with a harassment claim or something that's outside that workers' comp realm, so to speak.
So really more along the lines of PTSD, not just general workplace stress.
Yeah. And I think what Camille is alluding to would even be hostile work environment type claims, but then it leads towards an employment type claim rather than finding itself in a workers' compensation situation.
Right. I know one, stepping away from stress, one question I get asked quite a bit from my employers is, well, but he already had a back injury or she already had bad knees. Why am I getting this claim? So can you talk a little bit about pre-existing injuries and what that means? And
I can completely sympathize with that. It's got to be the knee-jerk reaction all the time. How could, even if something did happen, he already had a bad back. But the way that the law sees this is if a specific identifiable incident at work, it can't just be, I have a bad back and I was at work and then I just felt like I got hurt. There has to be some additional actual trauma that happened. But if there is, and it contributes to that injury, then it's up to that petitioner, it's up to the plaintiff to be able to prove that there's medical causation, that there's something that actually says this made it worse. In the absence of that, yeah, it could be that they're just exaggerating, and hopefully, on the attorney side, I can tell the employers listening to this, I am looking for that proof. If the person actually went to a doctor and something was identified, I want to know what that note says. I want to see what that history says. And if it says, there's a patient I saw 2 years ago for knee pain, but today he was stepping out of his truck and he twisted his leg because of X, Y, or Z. Okay, that's a history that says whatever that specific trauma happened contributed to whatever the condition of that body part was. So even though it might be frustrating, that is a legitimate claim, but it does require the petitioner to have that proof. They're the ones with the burden of proof in these cases. Is it similar to that concept of you take the victim as you find them, right? That I remember from the bar exam, and that personal injury concept of if I rear end your car, it's I take the victim as I find him, right? So it's along kind of those lines. Yeah, and the way I think of it is, you're talking about how are they at the point of time when the thing happens. So just because someone already has a bad back doesn't mean that they can just become paralyzed and then, well, okay. You think of it in the converse, if they've got lumbar sciatica and now they can't walk, well, obviously there's a new thing that's happened here. So that is the old phrase. You take them as you find them. I think it was like the eggshell skull plaintiff was the law school example that they used to talk about. Right. All right. Well, this has been really interesting. I have a feeling that we could go on and on and on and ask more questions. And who knows, maybe we'll have you come back and go and do more of a deeper dive in a future season. But we really appreciate you coming in and giving the employer that plaintiff side perspective, because I think you're right. You said it at the beginning that, it's not really a lawsuit. It feels that way. It can feel that way sometimes. And both sides can things can go off track if people think there's a game being played, even though it's not, right? So communication, documentation, all of that is key. It was my pleasure, you guys. Thank you so much for having me on. And maybe this demonstrates that plaintiffs' lawyers can be okay and reasonable to deal with. Hopefully. I like to get that message out occasionally. There's a few of you. Just kidding. All right. Well, thanks again for joining us, everyone, on Bees on the Law. We'll catch you next time.
Thank you for joining us on today's podcast of Bees on the Law. Don't forget to like and subscribe to our podcast. We also welcome any comments. If you'd like to get in touch with us or suggest a future topic, you can email us at beesonthelaw@gmail.com. And because we're lawyers, we need to remind you that this podcast is not meant to provide you with legal advice. and does not create an attorney-client relationship. Thank you again for joining us, and have a great day.